Hello everyone, and welcome once again to the Divorce Healing Center channel. I'm Anne-Louise DePalo, and every week I am doing a segment about divorce and how it can be used as a process to transform into something better. I had written a book which is Divorce Now What, and here it is, if you can see it. And I've been doing segments based on this book. And the book is about how to survive, thrive, and become truly alive in the divorce process. I have been doing process for divorce in the last few weeks. Basically, different ways that you could divorce. You do not need to only choose litigation and going to court and have a judge decide your case. There are many ways to be divorced. And it is your choice, and you need to decide what is the best fit for you and your spouse. Today we're going to talk about cooperative divorce. Now, when I wrote the book, I didn't really put a segment in about cooperative divorce. That was because I wasn't really doing much cooperative divorce, and I was really hoping that there would be more collaborative divorces. However, as I mentioned in my prior collaborative segment, sometimes a case cannot become collaborative. It may try to start out that way, but in collaborative, unless there is a signed participation agreement whereby the parties and the attorneys agree that they will not resort to court and that this is a collaborative process, it's not collaborative. People can say they're doing collaborative, but without a participation agreement signed and without the process being followed as a collaborative case, it's not collaborative. So that is why we have segued into cooperative. So many times, if a case cannot be collaborative, the attorneys who decide to try to still stay out of court, but act as if they are litigating. So basically, the same rules apply as if you are in litigation. However, you don't run to put the case on the calendar. You don't run to the judge. There are meetings, letters of settlement, exchange of financials, even sometimes picking certain appraisers with the attorneys. And there's also four-way conferences. However, both attorneys are acting as advocates for their own client, and there is a certain level of transparency because all cases of divorce, there is supposed to be a certain amount of transparency in finances. And in most jurisdictions, there's some type of a financial document that needs to be filled out whereby people swear that what is included in their finances is true and that they have not left anything out, omitted any assets, or lied about anything regarding their income or what they have or what they owe. But as I said, it's not a collaborative case. So if there is a mistake made by one attorney, the other attorney does not need to tell that attorney that there is a mistake. There isn't a speaking to each of the different clients. So if I represent a wife and the other attorney represents a husband, I can't do joint emails including their client. I cannot speak directly to their client in meetings. So there's still that level of, there's like a shield, which is sometimes hard to penetrate, and sometimes it helps. It helps sometimes, but it also hurts, and as a result, sometimes cases do not get settled. Also, they can start out very cooperative. People can try to be on their best behavior, but then if something goes awry or if someone becomes upset or angry, there is a chill in the air, and you can then feel how the negotiations are somewhat breaking down. However, if you have another attorney on the other side who has some form of either mediation training or best yet collaborative training and is an experienced matrimonial attorney who honors and respects alternative ways to divorce and an alternative dispute resolution, you might be able to have a cooperative divorce and have everything done as if it was litigated or a judge was overseeing it. However, you never step foot in court. This is important for a lot of people because they want to have more control over the decisions. It is less expensive because you're not paying for cases to be put before the judge. There aren't appearances that are needed whereby you need to either go to court or today Skyping or using Microsoft Teams, whereby you need to appear and have the case discussed with the court. You can go at your own pace, so that if you have ordered an appraisal and for some reason it's taking some time, sometimes if you have the case in court, the judges push to make sure the case is on track because they have what's called standards and goals. Basically, they have to have a case resolved within 6 months or 9 months or a year, whatever a specific jurisdiction requires. And they put pressure on the attorneys and the litigants to settle and to try to get everything done. This puts a lot of pressure on the clients and also the other attorneys. And sometimes it's not because of anything that was done by the parties or the attorneys. Sometimes documents are needed, or a pension appraisal is taking longer than anticipated, or a business evaluator is waiting for certain documents such as an updated profit and loss statement. Sometimes it's because it's tax season and we're waiting for tax returns and it's taking longer for us, the CPA or accountant who represents the clients, to give us the information that we need. So this is at least less stressful. It can go at your own pace. In order for it to work, both the parties need to work with their attorneys. The attorneys need to be diligent. They need to follow up with meetings, settlement agreements, settlement letters, getting information. You can't fall into a pattern of, well, there's no court date, so I can just put the file on my cabinet, in the cabinet or on the side, and not think about this until after the holidays. And then before you know it, months can go by without anything being done on the file. So what I would suggest is that you work closely with your attorneys. Choose an attorney that will do cooperative in the way it should be done, because if they aren't doing it cooperatively, you will have no alternative but to have the court decide. Either one party is going to become discouraged and upset that the other party's not moving, and then an attorney will have no alternative but to put the case on the calendar, and then you will end up in a litigated case. Also, work with your attorney closely. Be involved in your litigation. Ask questions, follow up, see where things are periodically. And do not hesitate to have an honest and open relationship with your attorney. So on our next segment, we're going to discuss contested cases. And then after that, I'm going to talk about how to choose an attorney. Chemistry is very important. So until then, take care. Until then, please hit the like button if this video was helpful. Please share, especially with someone who is contemplating divorce or going through divorce or has already been divorced. Check out my book on Amazon, Divorce Now What? And also please subscribe to the channel so you will be advised of when we will have our next segment.